A magistrate may take cognizance under section 190 of the Code of Criminal Procedure of any offence. Options are upon receiving a complaint of facts which constitute such offence or upon his own knowledge that such offence has been committed, upon a police report of such facts, upon information received from any person other than a police officer, then such offence has been committed, and all these. Here the correct answer is option 4, all these. Section 90 of CRPC deals with the cognizance of offences by magistrates. Question number 52. In case an application for bail is filed by the accused who is alleged to have committed an offence under section 376AB of IPC, in such case it is first mandatory to give a notice of such bail application before granting bail to the public prosecutor within a period of 15 days from the date of receipt of notice of such application. Second, mandatory to give a notice of such bail application before granting bail to the public prosecutor within a period of 7 days from the date of the receipt of notice of such application. Third, not mandatory to give the notice to the public prosecutor if the complainant or informant is represented through a private counsel. Fourth, not mandatory to give notice to the public prosecutor if the court considers it is not practicable to give such notice. Here the correct answer is option first, that is mandatory to give notice of such bail application before granting bail to the public prosecutor within a period of 15 days from the date of receipt of notice of such application. Question number 53. Any court may alter or add to any change before examination of an accused under section 313 of the CRPC, after examination of an accused under section 313 of the Code of CRPC, but before examination of defense witnesses. Third, before examination of any prosecution witnesses. And fourth, at any time before the judgment is pronounced. Here the correct answer is option 4, that is at any time before the judgment is pronounced. Question number 54. When in any warrant case instituted otherwise than on a police report, the accused appears or is brought to before a magistrate, the magistrate shall satisfy himself that he has complied with the provisions of section 207 of CRPC, postpone issue of process against the accused if he is residing at a place beyond the area in which exercises his jurisdiction. Option third, either inquire into the case himself or direct an investigation to be made by a police officer for the purpose of deciding whether or not there is sufficient sound for proceeding. And option fourth, shall proceed to hear the prosecution and take all such evidence as may be. Correct answer is option fourth, shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Now let us see the question number 55. When in a summon case the accused appears or is brought before the magistrate, the prosecutor shall open his case by describing the charge brought against the accused and stating by that evidence he proposes to prove the guilt of the accused. Second, the magistrate shall frame in writing a charge against the accused if upon considering a police report and a document sent with it making such examination as the magistrate thinks necessary, the magistrate is of the opinion that there is ground for presuming that the accused has committed an offence. Option third, the particulars of the offence of which he is accused and shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge. This is the correct answer. Question number 56. Section 293 of the CRPC regards reports of government scientific experts applies to the Director of Central or State Forensic Science Laboratory, the Deputy Director of a Central or State Forensic Science Laboratory, the Assistant Director of a Central or State Forensic Science Laboratory. Option 4, all these. Correct answer is option 4, that is all these. Section 293 CRPC talks about the reports of certain government scientific experts. Question number 57. The authorities of section 297 of the CRPC before whom affidavits may be sworn to be used before any court under the Code of Criminal Procedure may be sworn or affirmed before by any judge or any judicial or executive magistrate, any commissioner of oaths appointed by High Court or other court of session, any notary appointed under the Notaries Act 1952, and option 4, all of these. Here the correct answer is option 4, that is all of these. Section 297 CRPC talks about the authorities before whom affidavits may be sworn. Question number 58. The Code of Session shall ordinarily hold its sitting as per section 9 of the Code of Criminal Procedure at such place or places as the High Court may by notification specify of it any particular case. The Court of Session is of the opinion that it will tend to the general convenience of the parties and the witnesses to hold its sittings at any other place in the session division. Option second, at such places or places as the High Court may by notification specify if any particular case, the Court of Session is of the opinion that it will tend to the general convenience of the parties and the witnesses to hold its sitting at any other place in the session division. It may, with the consent of the prosecution and the accused, sit at the place of the disposal of the case. And option third, at such place or places as the state government may by notification specify, or if any particular case the Court of Session is of the opinion that it will tend to the general convenience of the parties and the witnesses to hold its sitting at any other place of the session division, it may with the consent of the prosecution and the accused sit at that place for the disposal of the case. And option 4, if at any particular case the Court of Session is of the opinion that it will tend to the general convenience of the parties and the witnesses to hold its sitting at any other place in the session division, it may with the consent of the public prosecutor sit that place for the disposal of the case. Here in question number 58, the correct answer is option 2nd. Now let us see the question number 59. The amount of compensation which a magistrate can direct the complainant or informant to pay for an accusation without reasonable cause under section 250 of the CRPC is, correct answer is option 3rd, as he may determine but not exceeding the amount of fine he is empowered to impose. This is the correct answer. Question number 60. Withdrawal of the complaint in a summon case under section 257 of the Code of CRPC results in acquittal of the accused. This is the correct answer, acquittal of the accused. Section 257 of CRPC talks about the withdrawal of complaint. If a complainant at any time before a final order is passed in any case under this chapter satisfies the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, or if there be more than one accused against all or any of them, the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint is so withdrawn. Now let us proceed to question number 61. At any metropolitan magistrate may, if he thinks fit, try in a summary way the following offences under section 260 of the Code of Criminal Procedure. Options first, theft under section 379, 380 or 381 of the IPC where the value of the property stolen does not exceed 2000 rupees. Option second, offences under section 454 and 456 of IPC. Option third, receiving or retaining stolen property under section 411 of the IPC where the value of the property does not exceed 2000 rupees. And option 4, all of these. Correct answer is option 4, that is all of these. All the options are the correct answers. Now let us see the question number 62. Section 363 of the CRPC entitles a person accused of an offence or to receive a copy of the judgment free of cost when he is convicted of the offence, he is sentenced to imprisonment. Correct answer is option 2nd, that is he is sentenced to imprisonment. Question number 63. In calculating the fractions of terms of punishment, section 57 of the IPC prescribes that imprisonment for the life shall be reckoned as equivalent to imprisonment for. Correct answer is 20 years. Question number 64. The maximum term of imprisonment which can be imposed by the court for the offence under section 304A of IPC is. Answer is 2 years. Section 304A of IPC talks about the causing death by negligence. That is, whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Now let us proceed to question number 65. Under section 63 of IPC, where no sum is expressed to which a fine may extend, then the amount of fine to which the offender is liable is prescribed as, correct answer is option 4, unlimited but directed not to be excessive. Now let us proceed to question number 66. Where an offence is punishable with the imprisonment as well as fine, the terms for which the court can direct the offender to be imprisonment in default of payment of fine shall not exceed 1/4 of the term of the imprisonment which the maximum fixed for the offence. This is the correct answer. Question number 67. In which case did the Supreme Court first hold that the right of a victim to file an appeal under the proviso of section 372 of CRPC is available against orders of acquittal rendered after 13 December 2009, and that for exercising such right no leave to appeal is required to be sought? Here the correct answer is Mallikarjun Kodagali versus State of Karnataka. This is the correct answer. Question number 68. In which case did a 5-judge Constitutional Bench of the Supreme Court consider the ambit and scope of 319 of the CRPC? The correct answer is Hardeep Singh versus State of Punjab. Question number 69. A instigates B to burn Z's house. B sets fire to the house and at the same time commits theft of property there. In such a case, A would be guilty of abetting burning of the house but not guilty of abetting of theft. Question number 70. The ambit and scope of the offence of sedition under section 124A of the IPC was considered by the 5-judge Constitutional Bench of the Supreme Court in the case of, correct answer is Kedarnath Singh versus State of Bihar. Question number 71. A knows Z to be behind a bush. B does not know it. A, intending to cause or knowing it to be likely to cause Z's death, induces B to fire at bush. B fires and kills Z. Correct answer is B may be guilty of no offence but A has committed the offence of culpable homicide. Question number 72. The offence of voyeurism under section 354C of IPC is committed when a man commits the act of physical contact and advances involving unwelcome and explicit sexual overtures. A man makes sexually colored remarks. a man who monitors the use of women of the internet, email or other form of electronic communication. Option 4, a man who watches or captures the image of a woman engaging in a private act in circumstances where she would possibly have the expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator, or disseminate such image. Here the correct answer is option 4. Question number 73. Hurt as defined in section 319 of the IPC is causing of the following to any person: bodily pain, disease, infirmity, and option 4 all of these. Here the correct answer is all these. Question number 74. Section 377 of IPC regarding unnatural offences was particularly struck down by the Supreme Court in the case of. Correct answer for this is Navtej Singh Johar versus Union of India. Question number 75. Stolen property as per section 410 of IPC includes property, the possession whereof has been transferred by theft, extortion or robbery, property which has been criminally misappropriated, property in respect of which the criminal breach of trust has been committed. Here the correct answer is option 4, that is all of these.